Hi, everybody. Welcome to WR Immigration's Immigration Options for the Sports Industry. We're going to be dealing with a lot of different type of classifications, different hot topics that are going to be dealing with the sports industry. It's a very entertainment-based industry. It's a very nice industry. We all like sports stars. We all like sports. It's something about sports that resonates with us. So we're happy to present this WR Immigration Sports Industry webinar. Just as a housekeeping, any questions that you have, feel free to put it in the Q&A box rather than the chat box. The Q&A box, that would be great. Just as we start all of our webinars, we want to start with a legal disclaimer. We are lawyers and legal disclaimers are appropriate. Anything that we're going to say today is really for informational purposes. It's just to give you a taste of what is going on in this industry, what's going on in this industry as relates to immigration and sports together. It's not meant as a do-it-yourself kit in order to practice law, immigration law. So it's really just to get to the questions and to get you to an attorney so that you can deal with the options with the professional. So this does not constitute legal advice per se. It's for informational purposes. And to act on any of this information, please contact an immigration lawyer so that you can do that in the correct fashion. A little bit about the firm, WR Immigration, we're a top-rated immigration law firm in the immigration space. We focus on high-touch, innovative technology in order to propel the immigration process to make it as seamless as possible. You can see on the left some of our awards and accolades. I'm Cliff Rosenthal. I'm one of the partners at WR Immigration. Been practicing immigration law for a while. My two esteemed co-hosts, my other partner, Rich Yemm, and Josune Aguirre Gamez, who is one of our senior associates. We are going to be talking today about immigration law and the sports industry and how they connect. So I want to start with Rich. Rich, why don't you tell us a little bit about the standard options for athletes, and just tell us a little bit about what we look for, what we try to gain, what kind of documents we should, we should present, and just kind of a feel for, what to do if you're an athlete and you need a visa, you want to compete in the US.
Yeah, absolutely. I mean, kind of one of the first things, if you're an athlete looking to come to the US, one of the first things you really need to figure out is actually whether you even need a work visa to begin with. You can see on the screen, and we'll go into these in a second, the O1 and the P1 are the two main visas, work visas that are used for athletes in this kind of field. But there are situations where you can just come as a visitor, B1, B2, maybe ESTA, something like that, just as a visitor without having to go through this whole process. Typically, this is very limited. The Foreign Affairs Manual really goes into a bit of detail on this, but typically, if you are an amateur athlete, which is kind of defined as someone who is not a member of any profession associated with that activity, someone who normally performs without remuneration, maybe there's some kind of allotment for expenses, something like that. An amateur, can come in and that side of things can be okay under the B1, B2, which is the visitor visa, or ESTA, these kind of visas. Alternatively, a professional athlete, golfers, auto racers, whoever it happens to be, who's going to receive no actual salary for being in the US, but they may receive some kind of payment in terms of prize money or something along those lines if they participate in a tournament, sporting event, and happen to win or place or get something like that. So there are options there, which could mean that you can just avoid any of this kind of area of actually having to go through an actual working visa, such as the O1 or the P1.
Rich, what about appearance money? If you're going to get prize money, you're not going to get prize money, they're actually going to pay you to play or to compete. Would that be considered a professional that could qualify under B visa or an ESTA? Or would you recommend one of the more traditional work visas for athletes in this case?
I honestly would start to recommend going towards an O1 at that point for appearance. I mean, I think it's probably a bit of a gray area. I mean, if the idea has always been that prize money for participation can be qualified under the B1, B2, but if you start to get into this kind of area where you're actually just receiving a salary or receiving payment during that time, I'm starting to go towards an O1, but I could be being a little bit more conservative on that. Would you agree, or do you tend to go the other way?
Yeah, no, I would agree with that. I think at the end of the day, appearance money does sound more like a professional that goes beyond just prize money. So sometimes you just have to be, you have to be a little bit careful how things are worded in contracts. You say you get prize money for appearance, and there are different things, and you have to look at each case in itself. But yeah, I would agree. I think certainly, well, the regulation is a little, or the fan note is a little bit vague. I think what's behind it is prize money and prize money only, and I think appearance money would certainly get you into one of the O1 P1s, which I think you're going to speak about right now.
Yeah, and I think just one other thing to add on that is just because technically it's listed in Foreign Affairs Manual and it says that you can enter to do these things, you still have to convince that CBP officer when you're coming into the country. And a lot of times that may lead to an issue. If they think, no, you're working, this is work, you need a work visa for this, they can still give you a hard time. As much as you can argue that, well, legally this looks like it's authorized, everything says it is, you can run into issues. So again, just something to bear in mind on that front whenever you're coming into the country. But yeah, to move on quickly is kind of O1A. So O1A is kind of a great category. I mean, there's O1A, there's O1B. O1B typically is more for the arts, motion picture, TV. O1A is pretty much for everyone else. And this is the one that we typically use for athletes in a particular field. The idea here is you have to be able to show extraordinary ability in that specific field, whichever field it happens to be. You have to meet, at least in order to show that you have that extraordinary ability, there's about 7 criteria. You have to show that you qualify under at least 3 of them. And these are criteria such as, showing that you've got an award, or you've won awards, you've got press about you, kind of high salary. All of these kind of things typically are what you'd be looking at showing. And I'm kind of focusing on the ones that typically we see more kind of come up within the athlete context. I mean, there are also criteria there, such as, publishing scholarly articles in the field, this kind of thing typically don't necessarily tend to apply. If you happen to have like a big international award, you've won, I don't know, kind of heads to go with an Olympic award or Olympic medal, something like that, you probably can just show that, get an O1, you're good to come in. But if you're not kind of one of those kind of elite top people, you're looking at kind of the lesser thing. You're looking to try and hit at least 3 of these criteria. Now, the O1 will be good for 3 years. You're coming in to work in your area of extraordinary ability. The O1 is job specific. So it does give you that ability to kind of come in and do work within that field.
Rich, let me just ask you a little bit about coaches. What happens with coaches? You've somebody who has been a star performer for many years, 20 years, retires, hasn't had a single coaching job, or maybe 1 or 2 small coaching jobs, and suddenly they want to apply as an O1A as a coach, but their field has really been as a competitor. Can you bridge that gap between coaching and competition in that way? Are they the same fields? Are they similar fields? How would you address that?
It's a great question, and it's something that's kind of gone back and forth with immigration. There's been some pushback on this initially, because the idea is, a lot of athletes, they've had a great career, and then a lot of athletes transition into coaching. And it's like, well, we did see immigration used to push back and say, well, you've shown extraordinary ability as an athlete, but maybe not so much as a coach. And that's what you're coming to do. So you need to be able to show that you have that ability as that. Things have kind of changed a little bit. They have started to kind of get a little bit nicer on that front. They've kind of basically said that if you have extraordinary ability as let's say an athlete, and you've shown that you kind of transitioned across into coaching, you've maybe got some work in that field and you've kind of made that move, it can be okay. I honestly have not really seen it be an issue. Sometimes the way we would almost position the person is almost as an expert within that specific field. So, you know, if it's an expert in, you know, Brazilian Jiu-Jitsu or something like that, we can show that that person, you know, is being hired here in the US based on their expertise as that, and kind of bring them in on that basis. So that side of things is pretty much worked. I haven't seen too many issues on that.
As you mentioned, I think immigration has gone back and forth on this. On the one hand, you know, people, you know, they realize that, you know, many top coaches gain their, you know, their abilities as athletes, and I think, I think that's quite right. And the current state of affairs is, you know, if you have a distinguished career, you can use that as long as you have some coaching. It doesn't have to be, you know, maybe as a usual coach case, you know, extraordinary ability in the coach per se, but you have to have something to show that you're coaching and that you have some ability in that, and then you can kind of tack on the athlete, your athlete accomplishments as well. So yeah, I think that's the current state. But yeah, as we said, it's going back and forward. It could change.
Yeah, and I think one of the other parts of this sometimes is, you know, just to help you make your case as strong as possible, is to kind of to narrow the field as much as you possibly can. You know, we've done cases, for example, where we've been able to narrow it to, you know, like beach tennis, for example. You know, if you tried to say this person's top in the world of tennis as a general rule, it's going to be a lot harder to show that person has met the criteria, or is kind of really at the top of that specific field. Whereas beach tennis is a much smaller field. It's a lot easier to kind of push the person to the top of that arena. So that's kind of, you know, some of the, I guess, tricks, but some of the kind of things that we've actually seen. But when you mention coach, you know, it can also work if it's a coach who's accompanying an O1. You know, you can look at doing an O2 essential support, which is the last thing on here, to bring that person in to be able to work alongside that O1 while they're in the US. The O1 would be the athlete, the O2 would be potentially their coach. But yeah, I think I'll hand over to Josune to kind of go through some of the P1A side of things, which is the other main work piece of things.
Thanks, Rich. Yeah, the P1A is a great tool, especially if you don't have all of the evidence necessarily to get to an O1, right? And some organizations just prefer the P1 to be able to put through more, you know, athletes into their organization. So the P1 is, you know, also requires a distinction in the field, but we don't have to meet all the other criteria that you previously mentioned. And the visa validity can be either 1 year for a team or can be up to 5 years, but it is specific to the event, right? So if the event is a contract for 2 years, then it's going to be a 2-year P1 visa.
So maybe Josine, maybe just talk a little bit more about the event. You know, event is something that we see quite often. So for instance, if you have a season, can that just be an event? What happens if you have a contract for, I don't know, just one competition, and that competition is going to be 1 day? How does that work? You get a visa for 1 day. Can you know, stretch it out into a season? You need contracts for everything. How?
Certainly want contracts for everything. Regulations and FAM has told us, you know, we can consider an event the contract, right? So if the contract is for 2 years, let's push for those 2 years. But we do get pushback, right? USCIS will question what is the event and whether, you know, I know we're going to go into that to the next slide, the criteria for that event. But right now, what we do is we include a contract, and if we don't have a written contract, we can also provide a summary of the oral contract and those terms to include the length of period.
So Rich, this also applies to the O1. So it's a similar event rule. How do you deal with that O1? Do you try to get it as specific as possible for as long as possible? You know what the client tells, what do you do when the client tells you, I have this person coming for 1 day to compete in 1 day, and they want a visa for longer than 1 day?
Yeah, it's definitely a tough situation. I mean, Josune was saying you try and get some kind of a deal memo or something, but itinerary is kind of what we tend to look at. A lot of sports seasons, tennis, golf, even skateboarding, they have certain tournaments that basically happen every single year. So you can normally get a good sense as to, and this is what I've done in the past, put an itinerary together that says, hey, this year we've got these particular tournaments lined up, and next year we're going to have these same kind of tournaments happening again and again and again, because that's kind of what the schedule looks like. So because of that, we've been able to kind of put together an itinerary that kind of stretches it out over time. I mean, like you said, if it is a one-day event, there's nothing else going to happen, it gets a bit tough unless you're able to say, hey, this company really does need this person to be available here for longer, because there might be additional things coming up, or there are additional things coming up that they need them to be here for. And that's kind of what we do on the O1, try and get it as open-ended as possible to kind of max out that 3-year validity if we can.
Yeah. Great. So one thing about the P1 in comparison to the O1 is a bit limiting, right? Where the O1, it's coming to the US to continue work in the area. Here, it's to perform in a specific event, right? And so when we have individuals who want to do something adjacent to their field, but not specifically an event, that's where we get into murky, waters, and may potentially have to suggest an O1 versus a P1. And Cliff, I know we were just dealing with this recently, individuals who want to have 2 valid O1 and P1 visas, and how practical that is with, trying to convince CBP officers why they're entering, right?
Right. So in certain sports, or in certain fields, what happens is that there's an entertainment part of what the athlete does, and then there's the actual competing. So for instance, in take MMA fighting, or some of the other sports, what they do is, for instance, there will be a competition, and then there'll be some sort of show where they follow their lives. There could be some sort of reality show about it, so it's unclear that the first the competition would definitely fall under P1, but maybe if it's just a show with no competition, it wouldn't fall under the P1. You'd have to do it in O1. So sometimes you have a situation where somebody's coming for both and needs an O1 and a P1, and you cannot have 2 statuses at the same time. So we left with dealing, you could get both, and you can come in for one and leave and come in for another to activate the next one. And it's probably not so practical. But I mean, it's doable if done right. But yeah, that's one of the challenges with these kind of different types of different types of sports. If you could get it all under an O1, it's probably better. But sometimes the level of the claim for an O1 is higher than a P1, so you kind of have to match and see which one's going to be more appropriate, if possible.
Yeah. And then to touch on the essential support. So what we usually do for P is, if we want to get in a coach or corner or somebody else who would qualify as an essential support, we go for the P1S. And I think, US Immigration doesn't question us too much on the P1Ss, as long as we can establish at least one, event where they work together. All right.
Let's go into to hot topics. Let's deal first with travel. Athletes, Josune, what kind of travel challenges, strategies do you look at?
Yeah, so I know travel issues have not been exclusive to just athletes, that it's been across the board, and we've been dealing with a lot of COVID delays and closures and so forth. But what we've been seeing for athletes is, for the most part, individuals, and especially their agents, help them in looking at flexible posts where they can obtain their visas. I think for one of the biggest issues we've had in the past, 2 years is trying to get Russians in, for example, and what to do with those individuals. And so what we've seen is a few posts will open influx of individuals will apply, that option will then close and we have to re-strategize, right? So it's just a matter of being able to understand the risk that you may go in, pay for a visa, may even get the appointment and then they cancel it, and have to then kind of go back to the drawing board. But we've had some individuals who were, successful in different posts like Mauritius, right? Seems like a beautiful place to go get a visa. Wouldn't be too mad at that. Where else? Fiji, right? Yeah. Although Fiji, they make you pay in country, but also wouldn't be too mad to go to Fiji to get a visa. So it's just, a matter of understanding that things change very quickly with Department of State, and also the availability. But as long as you keep apprised and, understand that you're going to have to be a little bit flexible, we've been able to get people in. But there is another part to that, is administrative processing, right? And I think some individuals are going to be subject to it regardless of their history, just maybe by nationality, unfortunately, and need to be prepared and strategize going to a third country if necessary and being stuck there for administrative processing.
What about vaccination requirements? Do athletes need to come to the United States with being vaccinated, COVID vaccinations? What's the current?
They sure do. I have not seen one individual successfully waive that requirement yet. Most, if not all, of the requests to waiver have only been for the COVID vaccine, and we have not seen that go down well. So yes, they have to show a valid vaccination record, and continuously check the CDC website to see, whether they've changed the accepted COVID vaccines or what they accept as fully vaccinated, right? And whether that changes that requirement to enter the US.
Right. Rich, why don't you speak a little bit about criminal records? Sometimes we find athletes with criminal records. Sometimes they have, a list of certain crimes. Sometimes they have been caught taking substances that they're not supposed to, even though technically it might not be a crime, or maybe it's a crime of possession of a certain class of a certain class of drugs. What are you seeing with criminal records? How does that affect an athlete?
Yeah, I mean, it's similar to what Josune was saying about travel and vaccination. It kind of applies to everyone, but it is something that you definitely want to consider if you've got any kind of criminal record, or if the athlete does arrests, convictions, anything like that. And like you said, if it's kind of controlled substance violation, there may not even be a criminal issue, but it could be something that could come up down the line. Because again, this is admissibility issues. If you could get a P1 and O1, you could get the petition approved, but when you go to the embassy, they're looking to see whether you are admissible. And if you have certain criminal offenses on your record, particularly like you were saying, controlled substance, any kind of alcohol, DUI type, even an alcohol related arrest, that can lead to either just straight inadmissible, not able to come in, or it could lead to a referral to a doctor outside the country for them to check if there actually is some kind of issue there. So there are things that you want to consider. There are waivers available, waivers of inadmissibility that are possible to get in certain situations. I won't go into kind of too much of the specifics on actually applying for those yet, other than to say they normally take a long time. I mean, we're normally seeing months unless you're able to get some kind of an expedite sorted. So, if you've got someone wanting to come in for a particular event that's coming up soon, and they've got that issue, it's something you definitely want to kind of get ahead of as much as you can.
What about admissions? So you go to the consulate and they ask you, have you ever smoked marijuana? And you say, well, yes, I did. But, in a place where it was legal. What does that mean?
I mean, it's not good. It is still federally, even though some states in the US have legalized marijuana, it can still, federally, it's still a crime, it's still a conviction, or still an issue when it comes to admissibility. So admission can lead to an officer, for example, finding you, if they're able to show they have just even reason to believe that you have maybe a controlled substance issue, or maybe you're a trafficker or something along those lines, they can use that to kind of say, hey, you are not admissible to the country, we're not letting you in. So this is definitely something to be very aware of. Maybe things will change in the future, but as of right now, federally, and immigration is federal, this is a problem. So something to definitely be aware of.
Yeah. Let's talk a little bit about NILs. The NIL stands for name, image, or likeness. And all of this is based on a Supreme Court case that happened in 2021. And this really applies mainly to college athletes. And what tended to happen is college athletes were forced to be amateurs. And as amateurs, they couldn't get paid for anything that had to do with their name, their image, or their likeness. So what could happen, for instance, is their picture could be put on a hat or something like that, and they couldn't make no money out of it. And I guess the school could make money out of that because they were not the amateur athlete. And this went all the way to the Supreme Court. They felt that this was a monopoly by college sports, in the sense that they were the athletes, but they couldn't get paid for their own picture, etc. And the court agreed with the athletes, and they said very specifically, in one of the opinions, said no other place, other employment situation could an employer do such a thing. And this changed the NCAA rules, and they passed an interim law. And now it seems that your name, image, and likeness can be used by college athletes. So that is what changed based on that Supreme Court case and the interim rule. But the question comes, what about college athletes that are on student visas? The student visas are F1 visas. They typically don't have work authorization. So does this mean that they can take NIL benefits, or in other words, be paid for NIL or not? And this is a great question, a very topical question, and something that immigration hasn't come back and said anything about this in one way or another. The silence is deafening, and it's this major question: is which an F1 student can sell their name, their image, or their likeness, and money for that, just like all other college athletes, or US college athletes, I should say, or others that have work authorization, because typically F1 students don't have work authorization. So that's kind of a big question at the moment, and everyone's kind of scrambling to work out exactly what the case is. So I think without any immigration pronouncement, I think you have to have very broad shoulders to say that this would be in that this kind of work, this selling these your name, image, or likeness would be considered something that could be done without work authorization. You do get paid for it, and whether it's employment, whether it's services, is just I think it is a very much a gray area. But I think you have to have very big shoulders to advise people, without any pronouncement, that this could be such a close question. There may be different issues if the actual picture was taken, abroad. Then U.S. immigration rules might not cover that at all, and you're just getting paid for something that was done abroad. These are all questions that are currently being discussed at the moment. There are no definitive answers as far as I'm aware. So check into that. Keep reading the news to see if there are any updates on that. So we'll see. Just going on to the next point, competitions and internationally recognized competitions. This is something we see really in the P1 arena more than the O1 arena. The O1, it seems to be, and I think there's an old memo that talks about, an old immigration memo, that the actual purpose of coming to the United States is, it doesn't have to be extraordinary in itself. But for the P1s, it has to be a competition, number one, and number two, it has to be internationally recognized. So there are some incidental things that an athlete can do, but generally they have to be coming to the United States to compete in competitions that are internationally recognized. So it has to be an athletic meeting, a competition, a season, something like that, number one. And number two, you always have to prove that, it's somewhat distinguished. And that can be done in a variety of ways. Certainly all the major leagues would have that, a league that has, lots of press about them, or awards, or is shown on, is televised. Those usually are quite, easy to do. And newer, smaller leagues can be more challenging to do this. But there's something immigration is focusing on, and we see a lot of requests from immigration proving that these are number one competitions, and number two, which is more common, that they're actually internationally recognized. So Rich, why don't you go into the next one, talk a little bit about Gamez, esports, are they sports? Do they follow the rules of sports, or how do you do Gamez?
Yeah, they are. Immigration has accepted that now. I think they were quite resistant at first as to whether they qualified as professional athletes, but we've pushed them on a lot of this stuff, and particularly with the growth of esports, which is just a huge industry now. And when you actually get into it, like a lot of esports or gamers, like they really do have to do a lot of conditioning and this kind of stuff prior to certain tournaments. So we've made that argument, immigration's accepted it. And yeah, it seems like it's here to stay. Esports works for Ps. You can use them under the O1. We'll get onto this in a bit. You can even kind of get green cards. Typically, the idea is they're supposed to be coming in to do some kind of a competition, championships, leagues, these kind of things. But yeah, definitely an option, and definitely something we've seen them do. And that also means kind of people who are slightly ancillary to that. I think you were mentioning, you sometimes can bring in commentators who are specific to that particular field under obviously different visas, maybe O1 or something like that. But it's definitely opening up a whole new kind of arena on that front.
Great, that sounds exciting. Okay, what about green cards? So we've spoken about O1s, P1s, Bs. These are to get your athletes in as quickly as possible. Those are normally your short-term options. They keep their residency at home. What about, they want to live in the United States permanently? They don't want to be, rely on visas, and they want to live in the United States. What can we do for them? Why don't you talk a little bit, Rich, why don't you talk a little bit about the EB1?
Yeah, green card options are definitely kind of have a lot of benefits. I think once you've got the green card, particularly if you've got dependents, we didn't touch on this, but the O1 and the P1 dependents do not have work authorization. So if you have a spouse, they're not going to be able to work. Whereas if you get a green card, you can get a green card for the entire family, and everyone can work at that point. But yeah, EB1, very similar actually in terms of criteria to the O1 that we mentioned earlier, but it is a higher standard. You do have to show sustained international reputation within the field. Similar criteria, is about 6 or 7 of them. You have to show you qualify under at least 3. So awards, this kind of thing. Honestly, if you've got an Olympic medal, that's probably, again, going to be sufficient for you to be able to apply for the green card, but it does take quite a lot longer than some of these other work visas. So, and until you get the green card, you don't have the ability to work. So most of the time, people are going to look to do an O1 or P1 first, and then maybe look to do a green card down the line. But the good thing with this is, once you've got the green card, the idea is that you're going to continue to work in your field of extraordinary ability. You can sign a statement that basically says, I intend to continue to work. So they're less worried about whether you have future projects lined up or, an itinerary of events. It's very much like, do you show that you're at the top of your field? You're extraordinary. If you do, great, you can get this green card. And again, with this one, we can narrow the field as much as possible. So if you're in a very small subset of a particular sport, if we can narrow that, it pushes you further to the top and gives you a higher chance of getting approved.
Great. Yeah, so it sounds like it's very similar to the O1. It's just a much higher standard in practice. Okay, the other option is EB2, and it's what's called a Schedule A Group 2, and it's instead of alien of extraordinary ability, it's alien of exceptional ability. So for those linguists who want to pass the difference between extraordinary and exceptional, you're welcome to do that in your own time. But generally, exceptional is considered a much lower standard. And as Rich mentioned, the EB1, especially the self-sponsored EB1, is a very high standard at the moment. So those that don't quite meet the extraordinary ability of the EB1, there is an EB2 Schedule A Group 2 that you have to show that you're exceptional. It's based on the matter of Masters, which is a very old case, and it's kind of questionable. Does it apply today or not? But it seems to be in the immigration policy manual, so they think it does. But essentially, it's a question of whether athletics, sports comes under arts or not. And based on old cases, that it does. And Schedule A Group 2 is possible. So the question is, you do need a sponsor for this, unlike EB1A, you do not need a sponsor for an employment sponsorship, employment contract. You have to show you're coming, as Rich said, coming to work in your field or to continue in your field of extraordinary ability, but you don't need an employer, you don't need a petitioner. But in the EB2 context, that might be a lower level of a claim required, but it's you do have to have an employer and a petitioner, which I would say the vast majority of athletes tend to work for themselves or not for an employer. There may be certain cases where they do, maybe they work for they're employed by a particular team, etc. So there are cases, but I think this is just a little bit more rare and infrequent option that we see, and most athletes actually go into the EB1.
And Cliff, I think you should brag about your special handling cases.
Thanks, Josune, for reminding me. So this is something we did for a coach, and one of the difficulties, and maybe coaches is almost like its own webinar in itself. But one of the things with coaches is whether they need bachelor's degrees, and whether you can get H-1Bs, which is the standard professional visas. We need O's for them. And similarly, the question becomes, what to do with them for green cards. And one of the options is this only applies to universities, is that there's a special handling. There's a special classification for those that are teachers, and they're teachers at universities. So although coaches aren't traditional teachers, we have been successful, and we were recently successful in the case where a coach was successful as a teacher, not necessarily as a member of the sports industry per se. And it was a very gratifying victory for us, because that's what coaches do, they teach. So that was a good one. Okay, so that comes to the end of the presentation. Okay, seems like there are no questions. Thank you for joining. If anyone does have any questions that come up, our emails and contact details are in the final slide. Feel free to reach out to any of us individually, and we're happy to answer any questions. Thank you very much.
Thanks a lot.
Thank you.